If you are a chartered accountant or a CA final student, you would definitely have studied the SEBI Act and various sections under it. But you would never imagine that how a section of SEBI could be used in the Income Tax Act and claim the deduction. So guys, welcome to Artist Perspective. This is my another video. This case is about a new deduction under section 37(1), which has been held by CIT Mumbai. Okay, so before I begin the case, we will understand this by a short story. Okay, here suppose I am the SSC. I have violated some provisions of SEBI, and SEBI had issued notices against me under section 12, 11, etc. And we have learned that in SEBI Act there is a section 15JB, which is a settlement section, which says that the person who has offended or violated any of the provisions of SEBI can settle, that is, he can pay some amount and can settle the litigation. That SEBI will accept the payment and will release the person from the offenses. Okay, it is like compounding of offenses. Okay, so I have offended and I have offered this offered a payment to SEBI, and SEBI has accepted this. This is the first leg of this case. Now what? Now I have gone to income tax. I have claimed deduction of this payment, that is this litigation, in my income tax return. So we will see what will be the fate and what has really happened to the ITR, to the deduction which he has offered in this case. What the AO, what is the claim of AO here? The AO stated that, see dude, you have made a payment to settle your litigation. Okay, then, and the amount of payment is quite high, that is in this case it is 50 crores. So this much amount has not been just paid to avoid the litigation time and cost. You must have involved in some offense, and you are paying that this payment as a settlement amount to settle the offense. That is, it is in the nature of penalty, and dude, you will not get any allowance under Income Tax Act. This was AO's claim. What the SSC's claim? SSC says that, see, I haven't incurred, I haven't made any violations, but in ignorance of some of the provisions of SEBI, I might have involved in some offense, and I do not want to go into a litigation battle to SEBI, and just to save my time and cost, I am offering this much of amount, and I want to get a deduction in this income tax. But AO has disallowed. Now the SC has gone to CIT. See, we know that once the assessment is over, AO makes an order. The SC have two options: either go to CIT or goes to CIT appeal. In this case, the SC went to CIT, and what CIT has made? CIT has referred to another case, which was of 2015, which the facts of the case, of this case and that case which the CIT has referred in this are different, but the judgment and the observations are similar. In 2015 case, the violations were of technical nature, and there were genuine violations of some technical grounds of SEBI or some other act, and the litigation charges has been paid. And in that case, the it was held that this expenditure is incurred for commercial expediency of the business and can be allowed. Now in this case, CIT has taken a similar view, said that the SC has not made any offense, but he just wants to avoid the litigation cost and save his time from the litigation, and he has made this payment, and this can be allowed under this section 37(1). That is, you guys can I will just what do you say, emphasis on this matter, that CIT has allowed a litigation charges expenditure under section 37(1). This is all about the cases. In here we have learned that litigation charges under any of the act, in this case SEBI has can be claimed as deduction under income tax. Okay, but I have two views on this case. The first one is that the government is really ignorant of what is the matter. The government do not know whether the SC is really a offensive person, or really have violated any provisions of SEBI or not, because the person who has offending any of the act should not get a deduction, but here the government is giving him deduction. It is kind of a impetus to the person that you can make whatever wrong you want, but you will be getting a benefit in income tax. This was the first understanding of me, and the second understanding about this case is that government is saying that, see, I believe that you are a genuine person, and you have mistakenly done a mistake. That is, in ignorance you have done a mistake, and since the penalties under that section, that act, are huge, you are offering a litigation settlement, and since I believe you are a genuine SC, you can get the deduction and carry on the business. So these are two thoughts. I don't know that what has been the thought of CIT, but if it is the first case, then it is a worrisome. However, this particular case will set a benchmark, and there will be number of associates in our industry who can pay a litigation charges and get a deduction in income tax. So it is a win-win for business concerns. So that is all about the cases, and that's it, guys. Stay updated, and thank you for watching.